Good evening. It is the 17th day of September, a significant day in the ICC case involving Kenya's Deputy President William Ruto and radio journalist Joshua Arap Sang.
Indeed, and for the first time, Ruto and Sang got to hear firsthand from a witness what they are alleged to have done.
And as always, we have lined up for you a comprehensive coverage of this historic trial. And we begin in The Hague, where KTN's senior national affairs reporter Rita Tinina is in place with a look at the day's events.
Good evening from The Hague, where the first witness in the trial against Deputy President William Ruto took the stand. Witness number 536 is said to have survived the attack on the Kiambaa church, which left at least 35 people dead during the post-election violence. The witness, who is a woman, will enjoy witness protection. She had her face blurred and her voice distorted as she recounted events of the post-election violence. KTN's Asha Mwilu has the highlights of the testimony by witness number 536.
To leave the church, they would...
Her image was pixelated and her voice distorted to conceal her identity, but her testimony was loud and clear.
Walikuwa ni watu wengi, karibu watu 1,000 walikaa chini.
There were a lot of them, many of them, about 1,000 of them.
But even before the prosecutor's first witness could narrate her experience in the chilling Kiambaa arson, Deputy President William Ruto's defense team was already raising the flag of a potential false testimonies.
Is the prosecution prepare a short pro forma document that should be signed by the witness, that the witness has been informed clearly and unequivocally that not only should they tell the truth, but that it is a criminal offence to perjure oneself that may result in imprisonment.
It's a we can rule on that we need not overstretch the matter or that exercise.
Seeking to open her case against Ruto with an emotional trip down memory lane, the prosecutor cross-examined witness number 536 on the horrifying Kiambaa arson attack, where more than 30 people were burnt alive in a church.
As those youth came closer, they sang, saying, "Hoi, hoi."
They set the mattresses on fire. I was trying to find some way to get out of there. It was difficult to get out of the church, since some people were in front of the small door.
She went on to describe the specific events she alleges to have witnessed.
She was taken by her legs. One leg on one side, another on the other side. She was raped. And afterwards, when I saw that she had been raped, I was surprised. And sometime afterwards, we called the notable person. That person was struck with an axe, and I just lost it, basically.
You mentioned that you saw a gentleman by the name of, or a person called Chemalan. Can you tell the chamber what are his full names?
His name is Stephen Kiplitin Chemalan. He was holding a blue container.
The proceedings were, however, not short of challenges. With the witness testifying in Swahili language, concerns were raised that some aspects were getting lost in translation.
Wengine walikuwa wamevaa vinyasa.
Some of them were wearing leaves.
The witness will continue her testimony on Wednesday, when the defense teams will get a chance to cross-examine her after the prosecution is done with its session. Prosecutor Fatu Bensouda is said to have lined up 10 witnesses in the case against William Ruto and radio presenter Joshua Sang. Asha Mwilu, KTN, Nairobi.
As the first witness took the stand, trial chamber number 5A went into several private sessions as part of measures to protect the identity of the witness. Witness number 536 is among ICC witnesses who remain anonymous to the public. But when, why, and how does the ICC protect its witnesses? I sought some answers.
Natamka kwa dhati
ya kwamba nitasema ukweli.
When prosecution witness number 536 took the stand before trial chamber 5A, the 37-year-old became the first to give her testimony against Deputy President William Ruto.
Ya Wakalenjin ambao wanakaa katika Kiambo village.
Ndio.
But her age and gender are perhaps the closest the public will get to know of the witness. She joins the list of ICC witnesses under the court's witness protection program.
Protection in this sense encompasses both the physical and psychological well-being of the witness.
When witnesses arrive at the ICC, they are first familiarized with the courtroom and court process.
A lot of witnesses may have never been in a courtroom before and might feel intimidated in front of a number of people and judges and lawyers. So they have to pass through this familiarization to know what they will be facing, who they will be facing.
The judges then assess and decide whether or not the witness requires protection. That was the case for witness 536.
This witness, so it is understood, has been assessed by the chamber and found to deserve protection measures.
The blurring of the face of the witnesses and the voice distortion are part of the protective measures for witnesses while inside the courtroom. Witnesses may also use pseudonyms. The protection extends outside the courtroom.
Helping them, ameliorating their own security if they are staying in the same place, being allowed to have a rapid intervention if necessary, and also medical care if it is necessary.
In court, the ICC says protection is also psychological. A lawyer or family member may be allowed to sit next to the witness to make them comfortable.
The witness have sitting with her during her testimony an assistant from the VWU.
In certain instances where the security of witnesses may be compromised, the court can order the relocation of witnesses, but only as a last resort.
Whether on a temporary basis or permanently, whether inside the same country or in another country.
In the William Ruto and Joshua Arap Sang case, not all witnesses may need protection. European-based witness Harvey Mopu, who will be testifying as an expert witness, is set to testify in open court.
A victim may be called as a witness, but it is not necessary that every witness is a victim, and not every victim will be called as a witness.
The push by Kenya to withdraw from the International Criminal Court has now found its way into the courtroom at the ICC. Legal teams are tomorrow morning set to make submissions on the effect a resolution by the Kenyan Parliament may have on the Kenyan cases before the ICC. KTN's Samogina reports.
William Samoei Ruto and Joshua Arap Sang.
Kenya's offensive to divorce herself from the Rome Statute has affected case one against Deputy President William Ruto and Joshua Sang. The prosecution says the Kenyan Parliament is partly to blame for the derailing of the trial.
And the prosecutor had indicated on the record that the reason, or part of the reason, why witnesses were unavailable was certain developments in the Kenyan Parliament relating to certain resolution passed.
The Kenyan Parliament's decision will on Wednesday be subject of the trial chamber. The prosecution claiming the withdrawal motion has had a direct bearing on the well-being of its witnesses.
We will take submissions tomorrow on whether or not the development in question is something that should be taken into account as a factor in the chamber's measures to in court protection measures for witnesses.
And as such, the prosecution and defense teams have been asked to submit their critique of Kenya's decision vis-a-vis witness protection.
We should be prepared to address the question, is it a fact that the Parliament of Kenya debated and adopted resolutions that may have any relevance to this case? If so, what? If so, when? If so, why?
This development coming hot on the heels of reports that 2 more prosecution witnesses have indicated their unwillingness to testify in the case. A few days after 4 witnesses bolted out, the prosecution has decried higher levels of witness attrition in prosecuting both Kenyan cases.
This trial is the culmination of a long and difficult investigations. It has been fraught with cooperation challenges and obstacles relating to the security of witnesses.
Meanwhile, the National Assembly resumed its session Tuesday with a renewed resolve to effect the motion that is causing heat at the ICC. Majority Leader Edan Duale intimating the bill to repeal the International Crimes Act will be tabled in Parliament Thursday. The National Assembly is seeking to compel the executive to petition the United Nations Security Council, signaling its intent to pull out of the Rome Statute.
We are dealing with the ICC issue politically, not only for Kenya, but for the whole of Africa.
When is the bill being tabled?
I have 30 days from the day the special session of the House was done. So watch the 30 days, count the 30 days.
While the trial chamber ponders on Kenya's offensive on witness protection, the appeals chamber is equally grappling with an appeal where President Uhuru Kenyatta and his deputy William Ruto want to be excused from attending all court sessions. Samogina, KTN.
Aside from submissions on Kenya's move to withdraw from the ICC, Trial Chamber Number 5A presiding Judge Chile Eboy Osuji also asked legal teams to prepare submissions on the issue of witness protection. The prosecution is expected to conclude with witness number 536 before the court breaks for lunch tomorrow. We are keeping it here in The Hague, and we will continue to update you on all the developments at the International Criminal Court. From The Hague, I hand things back to you in studio.
Well, thank you very much, Rita, for that. And as she said, we'll of course continue to update you on the developments at The Hague. Moving on, as Fatou Bensouda's first witness took the stand here in Kenya, a family was raising the alarm over their son, who they believe is also on the ICC witness list.
Now, the family in Maimahiu believes their son will be testifying against President Uhuru Kenyatta in November. But as Angel Katusi reports, they want the government to guarantee their security ahead of that trial.
Wagasha Waithaka sits pensively outside his Maimahiu home. His cigarette calms his nerves. He says, never mind that he has throat cancer, but this is the least of his worries. Waithaka believes his son is one of the key witnesses who are expected to testify against President Uhuru Kenyatta at the ICC in The Hague.
As a father, I cannot allow him to give evidence against the state.
News of his son's alleged testimony against the president came to Waithaka through people he claims were Europeans. Waithaka does not know much about them, not even their phone contacts. Waithaka's son, together with his wife and 3 children, have since gone missing. Waithaka believes they are most likely in protective custody.
I'm a sick man. I've got a throat cancer, and I would like to see my son. And then they told me they do not know where he is, but he's being held by ICC authorities. So, unless they contact the ICC authorities, it is ICC authorities who can now give permission for me to see my son.
Despite the elaborate measures the ICC has taken to conceal identities of the witnesses, Waithaka says he still has doubts over his son's safety and that of his family. Already 2 of his sons have been killed mysteriously, adding to Waithaka's fear.
Mimi sitaki kusikia mambo ya usaidi. Awachie tu Mungu atalipisha hiyo kitu anataka. Lakini usaidi mimi sitaki. Kama ndugu yake waliuawa na tujui waliuawa aje, awachane na hiyo maneno kabisa, sababu hiyo si usaidi.
The government of Kenya to make an arrangement, me and my wife, to travel to the ICC authorities wherever they are. We see our son, we talk with him.
Firm as his resolve may be, Waithaka may not be able to do much to dissuade his son from testifying, if the son is indeed a witness. But in Waithaka's mind, there is no doubt his son is at The Hague, and until he can see him, his cigarettes will continue to be his only comfort. Angel Katusa for KTN.
And let's still stay with ICC matters, and you will recall that last week the Senate passed a motion ratifying Kenya's withdrawal from the ICC. And this evening on KTN Prime, we're joined by Senator James Orengo to talk more about this. Thank you very much, Senator, for your time this evening.
Thank you, Yvonne.
Let's start off with that move by the Senate. Of course, many people saying that this is historic in many ways. The fact that we have a sitting president and his deputy for the first time before an international court, or indeed any international tribunal. Many are of the school of thought that this paints the country in bad light, and probably that's why the Senate is pushing for this. Tell us what you think about this.
I think we have to think about the history of how this came about. People think that the ICC has come here courtesy of the international community. But, the process after the post-election violence in 2007 in trying to restore peace and order in Kenya was at the initiative of the African Union. When Kofi Annan came to Kenya, he came as a representative of the African Union. And you could see during that process the majority of the members, in fact all the members of the panel, were former statesmen, or the other one was Gracia Machel and President Mkapa. So from the beginning, even the process that led to The Hague was on the basis of an African initiative. It was never from outside Africa. So at the beginning, the emphasis was that everything should be done in such a way that Kenya should be able to deal with these problems without going to the international community. And if not, let the African Union deal with it. But at the end of the day, the conditions that were established to enable the African Union or Kenya to deal with it were in fact not complied with by Kenya. Because there was an agreement which was signed by President Kibaki and Prime Minister Raila Odinga after consultations with the cabinet, that one, we had to have the International Crimes Act in place to enable Kenyan courts to deal with international crimes, because the international crimes were not recognized in Kenya under any statute or even the constitution. That did not take place until the year 2009. And when finally we had the International Crimes Act in place, when the prosecutor wanted to investigate the Kenyan situation, he gave a notice to Kenya, as required under the statute, that I'm about to start dealing with this matter. If you can show evidence that you are able and willing and ready to do it, I will not proceed. And that 30 days notice was not complied with. So, in effect, my belief is that we have made mistakes in the past, which took us before the International Criminal Court, and running away from it is going to be extremely difficult.
All right, and that is well explained here on this forum, but many have faulted the move by court senators to walk out of that session, in essence calling it a cowardly act, even though the majority may have their way, but the minority need to have their say. Why the walkout? Why not raise these issues within the Senate?
A lot of times these things happen in many jurisdictions, parliaments, when you feel your point is not being taken seriously. And I tell you, I have been in Parliament for a very long time. I was in Parliament at a time when there was only 7 members of Parliament who would take the government on, out of nearly 210 members of Parliament. The debates were mature. You may disagree with the government of the day, but when you stood up in Parliament to make your point, one could speak even for a week. And I remember there were times when a lot of people would disagree with what we were saying, but they stayed there, listened to the arguments. But right now, the attitude is that, we have the majority. It doesn't matter whether we are right or wrong. We can pass it. And I think that is very unfortunate.
But do you think the point is well made when you walk out?
Yeah, the point is well made, because
do we have the alternative voice?
Because parliamentary processes, may include filibustering. You may decide, to delay debate, to abort debate. So these are mechanisms that people use in parliament. So you remember, even at the time when we were trying to bring the multi-party system back in place, and President Kibaki was in the opposition. A lot of people were in the opposition at that time, including some who were in the Jubilee government. Right inside Parliament, we made it impossible for any debate to take place because the government would not listen. It was like we are remembering in 1982 when we went for a one-party system. There was a debate in Parliament, but only 3 people were allowed to speak.
All right. So what next then for CORD now that there's the walkout, and many feeling, okay, perhaps you should have been there, but then what next?
What next
in this process?
What next is we're still in the doghouse. We can't run away from the International Criminal Court because they are seized of the cases. They cannot be deferred. The only authority that can defer it back to Kenya by way of suspending it, not stopping the cases, is the Security Council. The circumstances under which the Security Council can do that is under Chapter 7 of the Charter of the United Nations. Those conditions don't apply to Kenya. So the best thing is to cooperate with the court. And I can tell you, 2 years ago when we were in Kampala on a review conference of the International Criminal Court, and Kenya is a member of the Assembly of State Parties. The state parties met in Kampala. They looked at the Rome Statute and considered areas of amendment. I would have been very happy if I heard from African countries that they don't like the procedure under which cases are taken to the ICC.
All right.
And an amendment would have been put on the floor. African members are in majority in the Assembly of State Parties, and they could have had their way.
Okay. We thank you for your time this evening and for shedding some light on that, and we wait to see how this one plays out in the Senate and indeed in the National Assembly as well. We thank you for that.
Thank you.
We've been speaking to Senator James Orengo on the move by Senate to pull out of the ICC. Let's move on to other matters now, and we move to Bungoma, where one of the advocates representing Musikari Kombo in a Senate election petition was shot dead earlier today. Lawyer Peter Wanyama Wanyonyi was gunned down as he returned home from a meeting in town. According to the police, Wanyonyi was shot at close range in the chest by the gunman, who escaped without stealing anything from him. In the case Wanyonyi was handling, Kombo is challenging the election of Moses Wetangula as Bungoma senator. The court is set to rule on the petition in 2 weeks' time.
Wanyama is my advocate, and you cannot take it lightly and stand there and just say it's normal thuggery. It's not possible. Within the people around me, there have been a lot of threats. In fact, the person that I thought would have gone is Barasa Nyukuri, who has been receiving very direct threats, phone calls, strange phone calls, asking where are you, and so on and so forth.
Right, and we want to take a short break right now on KTN Prime, but we've got lots more, right, Wilson?
Yes, we do.
National Museums of Kenya warns developers against encroaching protected archaeological sites.
Nairobi nilikuja na shilingi 3. Saa hii nakuja na shilingi 3. Sinakuja na 200 kutoka Kangundo. Kila kitu lazima ipande kulingana na vile wazazi wamezaa. Wachaneni na ukora ya kusema eti vitu inapanda. Si nyinyi mmezaa. Mimi nimezaliwa. Mimi nimezaa. Mtoto wangu amezaa. Mtoto wa mtoto wangu amezaa. Kitu itakosa kwa kale. Enda ina.